We're just going to do some brief introductions. We're the two student organizations who sponsored this talk today. My name's Christy Murphy, and I'm representing Criminal Law Society. If you have any interest in criminal law, you can sign up for our organization. We have a twin page where we post all of our events on there. We have a coffee hour next week, Wednesday, during lunch. We're going to have 4 defense attorneys coming in, and we have some other things planned, and you can view everything we have going on our twin page. So I encourage you to sign up and get involved if you're interested in criminal law.
Thanks, Christy. My name is Aisha Huck, and I'm the president for the American Constitution Society. Just a brief background, the American Constitution Society promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. ACS believes that the law can and should be a force for improving the lives of all people. With this vision in mind, we are revitalizing and transforming legal and policy debates in classrooms, courtrooms, legislatures, and the media. And we are building a diverse and dynamic network of progressives committed to justice. Through these efforts, ACS will ensure that the institutions of American law reflect the highest values of our nation and serve the needs of its people. With that said, the American Constitution Society does not take political sides when it comes to the ballot initiatives. Therefore, we urge everyone here to weigh the pros and cons and make their own informed decision on the matter. On behalf of the ACS Student Chapter, the Cincinnati Lawyer Chapter, and ACS National, I thank Professor Janet Moore and Stephen Johnson Grove from the Ohio Justice and Policy Center for engaging in this discussion and educating the UC Law community. Thank you for everyone who is here today.
Thank you, Christy and Aisha, Criminal Law Society, ACS, everyone who has taken the time to be here for today's conversation. Continue coming in and getting pizza. I know you're hungry. I want to welcome my friend and former colleague at OJPC, Stephen Johnson Grove, here to help us hammer out the pros and cons of a really important and interesting popular constitutionalist initiative. Stephen and I are accustomed to arguing heatedly about a lot of things. We don't see things eye to eye often. And you'll see that will be unfolding today. My task here is to channel some of my own reservations about Issue 1, but also to try to present pretty much left, right, and center the different points of criticism that I have gathered from across the spectrum. So I wanted to start, Stephen, if I may, just by setting a little bit of context in terms of
what
this popular constitution, actually, first in terms of popular constitutionalism in general. And so in Ohio is one of 18 states that allows the people themselves, and this is the language, the people reserve to themselves, Article 2, Section 1 of the Ohio Constitution, the people reserve to themselves the power to propose amendments to the Constitution and to adopt or reject the same at the polls in a referendum, okay? So this allows the people of the state of Ohio to propose constitutional amendments and see them into action. And Stephen will be telling us a little bit more about the particulars that they had to, the boxes that they had to check in order to get this to the voters in November. You should know, law students, that this provision of Ohio's Constitution was itself a constitutional amendment that was enacted in the 1912 Constitutional Convention, which was pushed primarily by progressives, but also by progressives of that day. The progressive movement was a driver of that, and there's a Cincinnati connection. The Reverend Herbert Bigelow of the Vine Street Congregational Church here in Cincinnati was a major driver behind this initiative, and that constitutional provision itself became a constitutional amendment because Reverend Bigelow and his supporters were unable to persuade the General Assembly to enact this provision as a matter of statutory law or as a matter of a constitutional amendment through the then existing provisions. Since then, Ohio's been quite active among the 18 states in terms of proposing constitutional amendments through popular initiatives. Based on the last count that I could see, though, Ohio is relatively low in approving these initiatives, about 19 of 70. And there's quite a range of them, many of which would perhaps not necessarily have fallen into the wheelhouse of the progressive movement that pushed for the inclusion of the constitutional amendment provision, the popular constitutionalist amendment provision in the Ohio Constitution. So I wanted to provide that for you just as a sort of historical background of where we are. Issue 1, as I understand it, aims to accomplish 4 major goals. The first is to reclassify low-level felonies, what are called in Ohio F4s and F5s, for drug possession. Reclassify those from felonies to misdemeanor. This is not decriminalization. This is reclassification, okay? So F4s and 5s for drug possession and drug paraphernalia possession would go down to misdemeanors, and that would be, if I understand correctly, retroactive if the amendment is passed. Second, the amendment would prevent judges from sending people who are on probation for felony convictions. That means you've gotten your conviction, you've either served your time and you're out, or you are out in public on probation under conditions. So you've got a probation officer who's supervising what you're doing, right? It would stop judges from sending people back to prison for what are sometimes called technical probation violations. The amendment calls them non-criminal probation violations, okay? Third, the amendment would allow for up to 25% of basically good time credits toward the service of a sentence by people who are already in prison or going to prison if they complete appropriate programming. And finally, there's a justice reinvestment component. That's the fourth essential component of this amendment. Justice reinvestment has been percolating around for a while across the country, and the idea is that if you enact provisions that will reduce incarceration, you can then take the savings that you're accruing by not putting people into really expensive boxes, and you can invest that in education, treatment, other programming that will prevent people from becoming involved with crime and in contact with criminal legal systems. So those are the 4, as I understand it, essential components of the amendment. And there are restrictions with respect to certain aspects of them, again, if I understand correctly, that there are restrictions with respect to violent offenders. In fact, the 3 restrictions with respect to violent, nonviolent offenders, so I'll let you offer that explanation in more detail. Okay, so that's the sort of historical overview of how did we get here, and then the specifics of this amendment and what it's aiming to do in sort of a quick and dirty view. So I want to start out with a question for you. Popular constitutionalism, in terms of this type of amendment, is often criticized as being a really blunt instrument to accomplish what is basically a legislative task that requires a lot more nuance and a lot more attention to detail about the way things are working on the ground. How do you respond to that criticism?
Yeah, difficult times call for big instruments. We are in the midst of 2 crises at this moment, all right, that one you hopefully have read about, I think, and given the number of people in this room, I guarantee there are people in this room that have been touched by it, which is our opioid epidemic, right? 14 people dying per day. I was at the Columbus Dispatch yesterday, and they have a nice collection of some of their most popular and eye-catching front pages. And the one that devastated me the most was the one from August 2016, which said 3,050, and it was an outline of the state of Ohio with lots of little people, little silhouettes in it. making up the number 3,050. That was 2 years ago. It's now 4,050 per year. That's 14 people per day. It's not stopping based on what we're doing. We know the war, I mean, we have 50 years of the war on drugs to look at that didn't do a thing to heal addiction, to reduce the flow of drugs into this country. You could I was talking to a police officer in Dayton about the price purity index, about how cheap drugs are and how pure they are. That has only gone, prices have gone down, purity has gone up. That is a steady flow. The war on drugs is an abject failure, and it's definitely an acute failure right now as we're looking at the number of people dying in the streets from the opioid epidemic. The twin crisis is the slow-moving juggernaut of mass incarceration, the leaden block of people that we have stuck in our Ohio State prisons. So we have 50,000 people in Ohio's prisons right now. We've had 50,000 since 2007, and like many states, it's I wish I had my charts to show you. Year and population, right? It's been, you all have seen it. The mass incarceration march in every single state, as well as the aggregate of America or the federal prison system, from about the late 1970s onward, up. And in Ohio, at about 2007, we got to about 50,000, and we've been there since then, like a little wiggle up and down. That problem, and now the state prison budget is $1.8 billion per year. So our contention is that we have ample resources in this state to address this very acute crisis of the opioid epidemic, as well as the much broader crisis of drug addiction. Those resources are just locked up in our prison budget. What we also have, if I could plot out on that same map, is big picture, headline-grabbing attempts by the legislature to rewrite the Ohio Criminal Code. 1996, Senate Bill 2. This kind of audience, certainly you, know that very well, our switch from what's called indeterminate sentencing to determinate sentencing. Lots of justifications behind that, one of which was we're going to right-size or responsibly, more responsibly use our scarce prison resources. Prison population continues to climb. 2011, we do, incidentally, there's two versions of justice reinvestment. Capital J, capital R is a brand name. From the Council of State Governments. So Council of State Governments is a big nonprofit in DC, really smart folks, came and did 2 years of data analysis in this state, proposed a piece of legislation that the legislature then cut to 1,000 pieces full of exceptions in 2011 called House Bill 86. Another gigantic effort. We're going to write, and that very explicitly was about we're going to shrink the prison population, we're going to put more resources in things that are more effective, more evidence-based treatment, more evidence-based protocols for safety. Prison population stays at 50,000. That was 2011. 2015, the legislature creates something called the Criminal Justice Recodification Committee. I don't know how many people have heard of it. And the reason you haven't heard of it is because it did nothing. My executive director was on it. David Singleton, your friend and mine, was on it for 2 years. Several judges on it. Justice Lanziger was on it. Several sheriffs, prosecutors, defense attorneys. The best criminal minds in the state, or criminal justice minds. And they worked really hard. The director of prisons, they rewrote, one of the best things they did is they rewrote the drug chapter, 2925 of Ohio Revised Code. Some really thoughtful things going on there. Do you know how many pieces of legislation came out of that thing? Bupkis. So while this is happening, this is why I want to, if you can imagine with your mind's eye, the handout that I don't have in front of you, which is lining up these charts, okay? Prison population, prison spending, opioid deaths. Legislation, failure. I'm done. The people of Ohio are done. We turned in 730,000 signatures from every single county in this state to get this thing on the amendment, or on the ballot in November, because people are so done waiting for this. So the legislature's failed. They cannot break out of this mold. The other thing I guess I should say is that's their attempts to do something progressive, that hasn't changed really anything meaningfully. Meantime, 10% of all the bills introduced in the state legislature every year, and you can look back at at least the last two General Assembly cycles, are creating a new crime or increasing criminal penalties. Crime of the Week Club, okay? That's what they do. That's all they know how to do. They go one direction. That's why the people of Ohio, and I'm so glad you cited Article 2, Section 1, or even going back to Article 1, Section 1, right? All political power is inherent in the people. First sentence. of the whole thing. That's what the Ohio Constitution allows for. This is the people of Ohio saying we want safety, we want health in our communities, but we don't want it to look like a cage, and all our legislature can give us is a cage. That's all they do. We're done. We have another way to do this.
But is it the people of Ohio? Didn't this come pretty much from California? Props 47 activists coming here, and George Soros, the Open Society Institute, the Zuckerberg-Chan Foundation. You've got millions of dollars coming in from outside of the state to drive this initiative.
So, for one, I wrote part of this. So I was, I'm part of a team of Ohioans. All this is by Ohioans and for Ohioans. I've been part of this campaign over 2 years, which was mostly built in church basements. Okay, I can't tell you the number of community centers and church basements I've spent time in building this campaign and writing this language. In January, and like after we've written the language, we've filed the language, we're already collecting signatures, we get an influx of cash, which is what you need to do to get these across. Yes, we did get money from those outside entities. For what it's worth, if you can compare it to some other, ballot initiatives in this state, like the casinos or the failed marijuana legalization effort a couple years ago, those were investments by people that were going to financially benefit, right? I'm going to invest in casino amendment because I'm going to set up a casino. I'm going to, the investors for the marijuana legalization, we're going to have the farms, right, or the distribution centers for that marijuana. Nobody that's put any money in this amendment is going to get a dime out of this. They have no interest financially in the success of this amendment. What they're interested in is the success of progressive causes in this country. Ohio is a very important state, as you all no doubt pay attention to, and national politics, what wins in Ohio wins elsewhere. So, and we're the epicenter of those twin crises. Like, we're sixth in the country, or seventh in the country in terms of general population, but we're fourth in the country in terms of prison population. So we outrank ourselves in our prison overuse. We also are, as we've said, the epicenter of this opioid crisis. So yes, there is national investment from people that care about something that important in a state that is this important.
But instead of actually solving the addiction crisis, the opioid crisis, isn't this amendment going to make things worse? Isn't this actually going to make the situation more dangerous for people and communities by, for example, allowing people to have massive amounts of fentanyl, a tiny amount of which can kill large numbers of people, date rape drugs, 2 pounds of marijuana? I'm not saying I had any experience with it, but that's a lot of ganja.
I did.
Okay. These are large amounts, or even small amounts, of really dangerous drugs. And people are going to be allowed to possess these drugs, not just once, but twice, without having any kind of significant criminal consequence as a result. Isn't this actually going to make things much more dangerous? And then you've got the earlier release proposal. The amendment carves out, as I understand it, murder, rape, and child molestation, but as at least students of mine should remember, or you will if you happen to have the bad fortune to be in my class in the spring, these terms don't really translate very well into the particularities of the Ohio Criminal Code, which is simply to say, you've got a lot of really serious offenses that may not hit the category of first-degree murder, say, or first-degree rape, say, child molestation, say. There's not really an offense that's called that. And these folks are going to be eligible for early release. We've got Marcy's Law. Aren't you going to set up an immediate conflict with the constitutional provision that was just passed to promote victim rights to prevent early release? Isn't that going to spin off a lot of litigation? So isn't it going to make things more dangerous? Isn't it going to spin off a lot of litigation that's going to, it's basically unfunded? How's that, how are you going to pay for all that?
So let's pull out, and then we just did 4
danger expense.
Danger expense. But there's, within danger, we talked about drug possession, drug quantities, how that's going to be dealt, and then the earned credit part. So let's kind of take these at piece by piece. Drug possession. So what our amendment does, as you very accurately said at the beginning, we convert what's currently classified as an F4 or F5 amount of drugs right now that you can, if you haven't seen, the Ohio Sentencing Commission has a handy-dandy little judge's cheat sheet for this, 2-3 pages. Has a chart for each substance in Ohio and, how much qualifies for which felony. So it's all based on weight, right, quantity in Ohio. So we're taking whatever is the F4 or F5 level for any particular substance and saying those are now misdemeanors. And so the claim has come up in many quarters, including from the Chief Justice and Attorney General DeWine, and I'm very appreciative of the Columbus Dispatch, which called it a lie, that we are going to let fentanyl traffickers run amok. Okay, so what our amendment says is that whatever the F4, F5 level of any particular drug, in this case fentanyl, is going to become a misdemeanor. Right now in Ohio, today, the quantity that qualifies as more than an F4, F3 and above, is 20 grams. So anything less than 20 grams is an F5. There actually is no F4 right now. That will change come Halloween. Actually, there's a bill just passed that, under our amendment, would not take effect as it relates to possession. We're going to separate possession and trafficking for a minute. So pure, simple possession, that is, the prosecutor can only chooses to prove the one factor of you have the drug, that would be a misdemeanor. Now, 20 grams or 19.9 grams of fentanyl is a lot of fentanyl. Okay, people are using dosages of like 1/10 of a gram. That would kill most of us, but if you're a high user, and you've got a lot of tolerance, 1/10 of a gram is a lot. So 19.9 grams is a lot. The street value is enormous, hundreds, thousands, and thousands of dollars. I don't know the exact math on that, but first of all, I've talked to state and federal prosecutors, and including a federal prosecutor that just wrapped up a case for 2 grams of fentanyl on trafficking. All they do in federal prosecutors, U.S. Attorney's Office here, both in Northern and Southern District, are trafficking cases. They have a federal law for possession. They could get people on that, but all they're doing is trafficking, and they're doing it at far less than 20 grams every day of the week. Same thing with our state prosecutors, prosecuting much less than 20 grams as trafficking every day of the week. That will continue to happen. That can happen now. Our amendment doesn't touch trafficking. The legislature, can change trafficking all they want. They can change the amounts that qualify for what felony levels or whatever penalties they want to attach to trafficking for any substance, and at any point after Issue 1 goes into effect. So I think it's a bit of a boogeyman argument that we're going to have people with these large quantities of fentanyl, pure fentanyl, running around and not getting prosecuted and only getting probation. I really think that's not realistic based on what is actually happening. The other thing you have to keep in mind, this is really for constitutional scholars, kind of interesting or legal scholars, the flip-flop we've had in Ohio about purity. You probably, the Gonzalez case that happened, what I'm talking about, with the weight thing. So, 2016, I want to say, late 2016, there was a state Supreme Court decision that said if you're going to prosecute somebody on any of these quantities, particularly for the kinds of, like cocaine, I think was the case, is you have to measure the actual amount of cocaine in the substance. So you can't just say it's 20 grams of a little bit of cocaine and some baby powder. You actually have to measure how much cocaine is in there, and then that's the felony level, right? Not the higher quantity. So the Supreme Court decides that. We have an election. One Supreme Court justice goes out. Another one comes in. Oops, we changed the majority. They call the case right back up, which is extraordinary. Talk to Professor Bettman. That's never happens. And they immediately have a different vote, and they flip the case the other way. So now the case, the law in Ohio is that you have 1/10 of a gram of fentanyl in a baggie of cocaine and baby powder and baking soda or whatever, but it's 20 grams. That's 20 grams of fentanyl. That's how it works now. So, yeah, maybe we do have people with 20 grams of fentanyl, but understand these are scare quotes under Ohio law of how much fentanyl we're actually talking about. When we're saying 20 grams of fentanyl, there's the legal version of that versus the normal human way of thinking about that. So again, not going to be this boogeyman amount of fentanyl. And the last thing I'll say on this, and particularly for criminal scholars, is our law in Ohio on trafficking is 2 factors, right? You have the drug, and then something else, either sale, obviously, that's an easy one, or prep for distribution, baggies, it's in the car, scales, a ledger, your cell phone data, you've been people calling you, the amount of cash you have on you. There's lots of other factors that are used to prove trafficking, right? These other constructive factors. So that's how it works. There are other states that have more generous. Now, I think, that, again, that under state and federal prosecutors currently are using that law to prosecute fentanyl traffickers every day of the week and will continue to do so. But if there's any concern after our amendment passes that they're somehow not able to get that guy with 19 grams of fentanyl that they think is really a trafficker, we can pass laws to amend the trafficking statute to make it yet even easier to prove, right? We could have presumptive trafficking at a certain quantity level, and then the burden flips. You could have possession with intent to deliver type statutes, which make it even a little simpler.
So then haven't you just undone what you've done?
Only insofar as we're talking about traffickers, which was never our intent in the first place, right? Someone with 19 grams who's actually a trafficker and you're proving trafficking, have at it. What I'm trying to do is get the people who are addicted with the disease of addiction out of the criminal justice system.
But don't many of them switch hit? A lot of addicts will have their supply with them, and they will also be distributing. And isn't it relatively easy for a prosecutor, and might it not tempt prosecutors then to overcharge? If the worry is we're going to have all these folks who are going to slip away from us, right? Then we're just going to charge everybody with trafficking. You know that happens.
Oh, they will. Yeah, they will. We figured that into our numbers. So we know that this happened. This happened with House Bill 86 and the capital J, capital R justice reinvestment we had in the state. That there will be prosecutorial and judicial resistance to the change. So I'm not concerned that that will happen. I mean, I'm disappointed that it will happen, but I know it will happen. Nonetheless, there will be fewer people going to prison for drug possession. Yes, we're going to unfortunately, I mean, that's true under current law, right? That's not my fault. That's the way the justice system works now, is that it hits the hammer on even people that are basically selling small quantities just to, sell to use. I'm sad that they're going to get caught up in it. I'm trying to at least get the people who are not trafficking at all out of this failed prison system. Yes, there may be some who really should get the benefit of our amendment that are still trafficking in these smaller, tiny quantities. I'm not done. This is step one. So yeah, for sure. So we just dealt with the drug one. You had like 4 other questions, really, earn credit and how we're going to pay for it. We can get there if you want to go there next.
Well, let me just bother you about something else.
Okay,
because
please.
you said, okay, you want to get these folks that are just using out of the system because the system has failed. Won't you also be getting these folks out of drug courts, which the evidence seems to indicate works reasonably well in a number of circumstances?
Absolutely.
And that happened in California after Prop 47. At least in San Diego, drug court participation dropped because judges no longer had the hammer of incarceration to encourage people to complete treatment instead of going into a box.
And in Oklahoma and Utah, it went up. So yeah, we've got mixed results there. Oklahoma and Utah both defelonized. Sorry, it's not even a word, but we'll use it here. Reclassified, let's say that. Drug possession from felony down to misdemeanor. And they both have very full and very active drug courts. And you're right, drug courts are very evidence-based. And the best thing about, I think, about issue 1 is it will create more funding that will be available for drug courts. You don't need the stigma, the permanent lifelong stigma of a felony or the hammer threat of incarceration to get people into treatment. We need more treatment available for people that need treatment. Chief Justice, when I have conversations with her about this, one might call them debates, starts off by saying addiction is a brain disease. We all know addiction is a brain disease. It's a brain disease. There is no other disease for which we do this, that we have to drop a hammer on somebody to get them well. Like, if we're going to call it a disease, we have to, judges aren't doctors. Like, there are some, I just met with the drug court judge in Warren County literally like an hour ago. He's an amazing guy, and I think he's probably one of the best in the state doing this work. And I want more people in his courtroom and fewer in the other courtrooms in that building. But by and large, people, and drug courts are very evidence-based in terms of their outcomes, particularly if you compare it to incarceration. Incarceration definitely doesn't work. If we're comparing conventional, horrible jail or prison to drug courts, you're still going to get better outcomes with drug courts. Now, let's compare having a whole menu of drug treatment available, all kinds of drug treatment, for different kinds of people and different kinds of substances, different severity of addiction in the community that doesn't require entry into the justice system at all. Compare that to drug courts. And I think you're going to get a lot cheaper, better outcomes there. So I want both.
That's a hypothesis. Do you have a real life experiment? Does that nirvana exist somewhere? Where you've got available treatment? Come one, come all?
What we've got is the experiment in the states, the 11 states that we know do not, that all or nearly all drug possession is not a felony, it is a misdemeanor. And that particularly in the recent ballot initiative examples, both California and Oklahoma, that there's no correspondence in terms of public safety increases or what am I trying to say, worsening because of that choice, right? So there's no, Pew Center on the States, Pew Charitable Trust put out a report in March that looked at, the severity of penalty, felony, misdemeanor, prison time, versus other social or health indicators, drug use, overdose deaths, violent crime, property crime, all those things. No correlation whatsoever in terms of choosing to reduce the penalty on drug possession and those other sort of indicia of something going awry, right? So that's...
Car thefts went up in California.
Okay, car thefts went up in California. All right, perhaps.
No, they did.
All right. Thank you. Thank you for that.
So let's circle, I want to just follow up on the danger question.
Yes.
In two further respects. The first is with respect to early release, which I mentioned a few minutes ago, right?
Correct.
And the second one really is with respect to these non-criminal probation violations, right? Mm-hmm. If judges are not allowed to drop the hammer on people who are on probation and who are not complying potentially in really dangerous ways. They move without telling the probation officer where they've gone. They're contacting the victim when they're not supposed to. Technical, non-criminal probation violations. They're not reporting to their officer when they're supposed to, right? Isn't it a real risk that you could be creating much more danger, including to victims of these perpetrators, by preventing judges from incarcerating them, at least from exercising their discretion, which is a separation of powers issue, right?
Well, I mean, the laws are always there to tell judges what they can and can't do. I don't think that's separation of powers problem, unless I'm misinterpreting your question. But they can definitely incarcerate them. That's the little misperception there on our probation reform. So what our probation reform says is that if you have a non-criminal or technical probation violation, you're violating, there's, I guess, three big ways one could think about probation violations. You're on felony probation, you commit a new felony, you're definitely going to prison. You're on probation for a felony, you commit a new misdemeanor, maybe you're going to prison. You're on probation for a felony and you you break some rule, of which there are hundreds. I mean, it is very hard as a person on probation to live your life, associating with known felons, which in some people that means walking to the corner store, having a dirty urine, not paying your restitution, which, by the way, it's hard to get a job when you have a felony. There are all kinds of things. And then there are, at the other end, within that spectrum of the non-criminal part, this is rule violations, there's definitely the dangerous ones, right? Somebody convicted of domestic violence lurking around the victim's house, and your other example as well. And what issue 1 says is that it must be what's called graduated responses or graduated sanctions. It's a term of art used throughout probation in this country. It's sort of the state of the art and like what's effective for probation. That is, if you string people along, this is what happens a lot in Ohio, including the judges that complained to me about this probation reform. We're going to haul you in for violating probation and yell at you, 6 or 7 times, and then we drop the hammer of state prison and destroy your life. Like up until very recently, the minimum sentence for a probation violation was 1 year. So nothing, 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 bam. And as parents, I think we can both agree that's a terrible way to correct any behavior. And it's true for adults as well as kids. I'm not going to do anything to you until, this horrible, horrible thing. What issue 1 says is you've got to use the evidence-based graduated sanctions, smaller penalties. We're going to increase the number of times you have to meet with your probation officer. You're going to have home incarceration, the ankle monitor, more frequent or random drug testing, all kinds of things like that. And it includes, very explicitly in our amendment, up to and including incarceration in jail. So if somebody's doing exactly what you said, my anticipation is that a judge would put that person in jail in a hot second. That's probably appropriate.
Jail as opposed to prison.
Correct.
Local.
Right. So their incarceration is definitely permissible for those dangerous, non-criminal forms of violation. And our amendment says that you can, for misdemeanors, for a new misdemeanor or a new felony, you can definitely go ahead and do, if you can send them to state prison, that's absolutely allowed. It's worth noting, our prison population, as I've said, it's at 50,000, and I sort of characterized it earlier as this leaden block. It's actually, what that number masks is the churn. So we have 50,000 in state prison, we have since 2007, but there's 20,000 people going in every year and 20,000 coming back out. So we have these like short-termers that are like churning through really fast. A full quarter of those people going into prison every year are for probation violations that are not new felonies. So it's the misdemeanors and the technicals. So it's a huge driver, and that's why we put it in our amendment. We would design this intentionally. We're trying to cut off the flow of the lowest level stuff that just doesn't belong there, doesn't belong in that expensive, failed institution.
Isn't this unnecessary? TCAP is already taking care of it. TCAP is a mandatory program now for the 10 counties in the state of Ohio that have the largest populations. And those are the counties that send the highest number of folks to ODRC, the state prison system. And what TCAP requires in these jurisdictions, and it's expanding across the state as I understand it, is a big chunk of these folks that you're concerned about, the F5s, the nonviolent lowest level offenders, who are about 20% of the prison population, at least as of 2017. If they're going to be, they're not going to be able to serve time for those offenses. You got to keep them home and treat them is the idea. And so the response, at least from some judges who are administering this program, is we're already doing this. The people that you are worried about, these F4s and F5s, the reason that they are at the big house is not because they got a dirty urine once. It's because they have shown a pattern of being incorrigible. And even if they came in with some low-level offense, maybe what it is they got charged high and they pled down because they flipped and they got a good deal. Or they have just pushed the boundary as far as the judge can tolerate it, because the judges are under pressure to not send people to the big house. And so they are exercising discretion now, especially under TCAP, to keep these folks out. So it's not only dangerous, this amendment proposal, it's also unnecessary.
It's definitely not dangerous, and it's definitely necessary. And I think I've dealt with the dangerousness part, but the necessary part, so yeah, TCAP was passed in the state budget bill last year in House Bill 49. It basically incentivizes counties to not send people, a certain class of nonviolent F4s, F5s, if you don't send them to state prison, the state prison will actually redirect money out of their own budget. DRC, our Department of Rehabilitation and Corrections, sends a check back to the county to spend on local justice programs to then hopefully prevent people from coming in, like a virtuous cycle, right? It's a virtuous cycle in the mini, okay? So in the first year of TCAP being in place, we've had 500 fewer people in state prison. That's great. I'm all about TCAP. In fact, I think these two things complement each other nicely. If issue 1 goes into effect, and I cite not only my own internal data, but data from the Policy Matters Ohio, which I encourage you all to look up. Policy Matters is out in Cleveland, and they did an analysis based on original DRC data and looking at our amendment. And what they said is in the first year, we're going to have 10,000 fewer people in state prison. That's impact. That's what I want to do. Okay, TCAP is great. I want TCAP to keep going, and I hope TCAP money and money from our amendment goes to counties so that there's more treatment available at the local level. Let's do both. All hands on deck. 14 people are dying a day of this opioid crisis because we invest in cages and cops and billy clubs and belly chains. I took that from you, by the way. and not in the treatment that we need, the full menu of treatment, not just one kind. There are counties that have no drug treatment provider at all. We need, everything from crisis intervention at the front end to inpatient treatment, outpatient treatment, peer counseling, sober living housing, all kinds. You got to have all of the above if you're going to win, if we're going to win and make Ohio healthier. And so we have to stop doing the thing that doesn't work and invest in the thing that does.
All right, now I'm going to hit you from the left.
Hit me.
Show me the money.
Show me the money.
Okay, this is a pipe dream. Justice reinvestment has done nothing anywhere in the country except to extend the carceral state in new amoeba-like local directions to ensure that there is more and more surveillance and control, mostly of poor people who are disproportionately people of color. Why is this hope that this form of justice reinvestment is going to be anything more than the same chimera?
So again, let's disassociate the capital J, capital R brand of justice reinvestment from what I'm trying to do. So capital J, capital R is something, again, run by something called Council of State Governments. It's a think tank. And they do a great job at data analysis. They're incredible. I mean, they're some of the smartest people I've ever met. And they're here in Ohio again, by the way. There's Justice Reinvestment 2.0 happening right now in terms of the data analysis and policy proposals. They haven't churned out legislation yet. But they're not real great at politics. Somehow the power of the tough on crime narrative as it seeps through the state legislatures, and I've been in the rooms and watched it happen, they don't fight back when Senator so-and-so says, no, I don't want that, and I don't want that, and I don't want that, and we need an exception to this one, and by the way, we're going to cut out this whole section. Like that's what, so all the justice reinvestment bills that have happened, the first version is amazing, and then by the way, by the time it makes it through the sausage machine of legislation, it's full of so many exceptions it has no impact. So in fact, justice reinvestment, if you look back at their own promotional materials, when they started out in the very early 2000s, they talked about actually reducing prison populations. They actually don't say that anymore anywhere. They only talk about controlling prison spending. So maybe we'll bend, the prison population goes up, we're just going to bend it down a little bit. I'm not that.
Why not?
I'm not that because, well, first of all, that's why we went constitutional, so we wouldn't die the death of 1,000 cuts through a legislature that's bent only on incarceration.
Yes, but where's the money going to come from? You're going to have to run it through the Department of Mental Health, and you got to do grant programming, and then the legislature's going to have to do this and that. It's going to be slow and unwieldy, and you still are going to be subject to death by maybe 99,000 cuts.
Maybe. So let's talk about how our amendment works. So in our amendment, and you all have this, I think, my little handy dandy handout, chapter and verse. So
they have access to two handouts.
Oh, that's very good.
One pro, one con.
Yes. I'm going to withdraw. Okay, I'm going to hold back my comments here. So our amendment has a very detailed calculation. So for each person not going into the prison because of our 3 reforms, so the reclassification of drug possession, the probation violations not going in, and the expansion of earned credit, each person not in prison because of those reforms, we have a number of dollars per person per day, $30 or $40 per person per day. And you can read it in detail in section I of the amendment.
How'd you come up with that?
We did the math on prison budgets. We looked at all sampling of institutions. There's 28 prisons in Ohio. We looked at several with high and low expenses and tried to figure out how much, if you take a person out of a state prison, how much do you actually save? Right now, the average cost per person per day is $70. But of course, if you take one person out of prison, the lights are still on, the guards are all still there, the food's still being served, costs aren't going to go down that much. If you take out 10,000, you're definitely going to get a lot more impact, but you're probably still not going to quite achieve the full $70 per person per day. So that's how we got down to the $30 and $40 per person per day. What our amendment says is you have to first estimate the number of fewer people that will be in prison because of our amendment. We've done that.
You have to do that.
No, the Office of Budget Management, so like the governor's office that does the budget creation every year.
It's their job to do that estimate.
That's right. Now, we've already done it ourselves, as well as I mentioned Policy Matters Ohio. Their paper has done it as well. We've looked at DRC data. We've looked at our reforms. And even when we cut 20% off, anticipating that judges and prosecutors will find an end run around our reforms in some way or another, we depressed our impact numbers, we still think we'll have between 9 and 10,000 fewer people in prison. And that means between $100 and $130 million per year aggregated up, okay? So that $130 or $100 million per year then gets split up. 70% of it goes to the Department of Mental Health and Addiction Services and then goes out through a grant program. That is going to be available to really any applicant, and this is spelled out in the amendment as well, that can demonstrate that they're evidence-based, that they're like effective at doing drug treatment, that they're serving a place or a population that has a high need, and that they have a quality program. So we were very detailed about both how the cost savings are calculated and captured and how they're reinvested. And it's prospective, so this will come into effect. The money will be available in the first budget cycle that this is in effect. So that's July 1st, 2019.
The constitutional amendment will require the legislature to allocate that
That's right.
much money.
That's right. And they have to do it prospectively. And then at the end of the biennium, if there was anything wrong with the anticipation, there was fewer, they undershot and there was actually fewer people in prison, or they overshot and there was more people in prison than we thought because of our amendment, they do what's called true-ups. So in the next biennium, they either increase or decrease the investment accordingly. Right? So that it's trued up to what the actual impact was after the biennium.
So that's 70%, and then the other 30% goes to victim services?
That's right, to the Attorney General's office. The Attorney General right now administers several streams of victims of crime funds. VOCA is a federal thing, Violence Against Women's Act, and then there'll be our funds. 15% of the money is for trauma recovery for the survivors of violent crime, because that's another driver that's unacknowledged of violence and of incarceration. Like, women are the fastest growing part of our state prison population. They outpace men, and so over the era of mass incarceration, one could look at late 70s to now, the men's population has gone up multiplied times 4, which is awful. The women's population is multiplied times 10. And it's driven by primarily drug charges, but underneath that, when you talk to women and when you do the data analysis on the deep kind of social science studies that have been done, is that that's really driven by experiences of trauma that have been unresolved. That's why we're investing money in trauma recovery for crime survivors.
So the last place I'm going to hit you, and then hopefully we'll have a little time for Q&A with the wonderful folks that have sat here so patiently. From the opening statements of this amendment, you make this hard and fast distinction between violent and nonviolent offenders. And every social scientist, John Pfaff, the National Academy of Sciences, Marie Gottschalk, is saying this drug reform stuff is not where it's at if you're really interested in reducing incarceration. That you have got to attack the extensive, from their perspective, the excessively long sentences that the United States, jurisdictions across the United States, Ohio including, if you do a global perspective, right? What really is happening here is you've got people who are being convicted of violent offenses being sentenced to extremely long terms in prison. And this amendment, I would argue, reinforces that problem by making this distinction between violent and nonviolent offenders.
Yeah, one, I completely agree with you. If we're going to deal with mass incarceration as well as make our communities safer, we have to think much harder about how we choose and use incarceration as a tool. One of my favorite, somebody I hope we get to Cincinnati someday to speak is Danielle Sered. She runs Common Justice in New York. It's a victim-led, crime survivor-led restorative justice program. They work exclusively with felonies out of Brooklyn, and they work with violent offenses in Brooklyn. And what they do is they basically give the victim a choice. Do you want to go through the regular prosecution and incarceration system, or do you want to come to us? And what that means is we're going to work with the person who perpetrated the crime and you separately for a while, and we're going to bring you together and then talk about what you need to get healing and feel safe and feel like there's some form of accountability. And what she often said is this amazing program that's sort of an aside. We're not doing any of that here. But what she says is that, you know, prison is like throwing a Molotov cocktail on a fire. I mean, like, yeah, there's violence, and you know, choosing prison as a response to violence is often makes things worse. And as you can tell from my approach to the state constitution, as well as everything else I've said here, I'm a very realpolitik kind of person. I have to win this. We have to win this, okay? We're here to win. And so we have to go as far as we can take the Ohio electorate, which is not going to vote for something that reduces crimes and violent, you know, reduces penalties on violent crime. So what can we do?
They also won't vote for something that allows fentanyl to be spread around without heavy penalties.
Which ours doesn't do, and I think I ably answered that question already. But we'll see we'll see. We have November 6th is coming.
Should we let them?
Yeah, well, I just want to say the one place where we don't do that is the earned credit part. We didn't talk about that. Maybe that can be a Q&A, and I won't go into detail on it. I'll just say that our earned credit, you know, we do exempt murder, rape, and child molestation, but every other form of offense, we allow those folks to earn credit because the programs work, okay? The building behind us, right? UC Criminal Justice School has been working, has been at the forefront working with DRC for years on evaluating the effectiveness of the programming in prisons because they work, they reduce recidivism, they make it better. That's what we want to do with people even who've been charged with violent offenses. All right, let's go to questions.
So just going off what you said, you're trying to take the electorate as far as you can go. Is the next step after this, your push going to be a complete decriminalization or legalization of all of these substances? Because right now it seems like if you're just moving it from a felony standpoint to a misdemeanor, you're still going to be a lot of money being spent in the prosecution, both the police and on the legal side, and it's still this
bill case. Yeah. So not me. I will say that one of the people who invested in the failed marijuana thing last couple cycles ago, right, has already announced that they're going to do a marijuana legalization amendment maybe next year or the year after. I don't know. That's not my job. I'm not. You know, I don't even really know them other than their name. So that's not me. What I'll be investing my time in probably is bird dogging this thing because there's going to be so much work for implementation. Make sure it's done faithfully, looking at the legislation and the rule creation. That's where I'm going to be spending most of my time. Now, I'm not holding out. You know, I'm not saying I'll never push for something like that, but it's not on my agenda at all.
Anything else?
Yes.
So yeah, say this does get passed and goes into effect. So people who are affected by this, like as far as people with the felonies, what's going to be the process of getting those felonies off of their record? I'm sure it doesn't automatically come off. Like
No.
Did everybody hear the question?
Yeah. Okay. So. All right. So what's the process, and then what's number two?
Are there any initiatives that are like the goal is to kind of get these kind of drug offenses off, or like get the question off job applications? You know, that's one of the big collateral consequences.
Yes. Yes.
Are there any initiatives, you know, you put forth or that included?
Yes. Okay. So this amendment, I'm going to ask the second one first because that excites me. You're in my wheelhouse. So since I started doing this work, that's what I've been fighting for, is what's called ban the box, removing the question from the job application that says, have you been convicted of? And we won it here in Cincinnati first in 2010. We then won it in 14 other cities and counties across the state, and then we won statewide legislation already in 2015 that banned the box from public employment. So all government jobs, state and local, county, everything in between, do not have that question anymore. And if they do, they're running afoul of the law and I need to sue them. But that is already the law. So the next step is to push that out to the private sector. And I don't think I could win that right now through the state legislature, but believe me, it is on my to-do list. Second is the process. So what it says in here, and you mentioned that from the very beginning, is the retroactivity part. We didn't barely touch it, but when people have these drug possession felonies from any time in the past, or are currently in prison because of them, if the only thing that keeps them in state prison right now is one of these F4 or F5 drug possession felonies, they can petition the court that sentenced them to have it reclassified down to a misdemeanor. And the court shall, it's very strong in here, reclassify them unless there is a, let's say, how do we say it? Individualized, particular, they shall reclassify unless there is individual particularized facts that indicate that the person is a threat to public safety, something like that. So we do have a safety valve in there if there's really some reason to not reclassify the person's offense. But otherwise, all these folks from tens of thousands, I talked about 10,000 fewer people in state prison. I have not yet figured out the tens of thousands, and I'm going to be soon, we're about to publish a report on it, but many tens of thousands more that are going to benefit from this amendment because they have a felony from 20 years ago, 10 years ago, that's one of these drug possession felonies. They can get it reduced down to a misdemeanor. And forgive me, I'm just a little point of indulgence. Our office has the best database in the country that can tell what are the barriers that attach to you once you have a felony record. So it's called the Civic Database. I've done presentations for your class and others, Professor Bettman's class, I think, around the Civic Database, C-I-V-I-C-C, 2 C's on the end. If you Google that, we'll always be first in all the Honda Civic advertisements after that. It says, if you have thus and such criminal record, here are all the jobs under state regulation you can't do. And for a felony drug possession, it's 573. For misdemeanor drug possession, it's 250. So you cut more than in half the job barriers that someone has if you reduce a felony drug possession down to a misdemeanor. So the tens of thousands of people that will go through that process, petition to get it reclassified, suddenly there's like whole sectors of the economy that are open to them.
Anything else?
One more thing. When is the last day to register to vote? Do it, and then vote. Thank you.